Okay, let's dive right into this explainer. If you're building a business, your equity is, without a doubt, your most valuable currency. But, far too many founders treat their company shares like a pie to just be sliced up and handed out. They don't realize the immense power and flexibility the law actually gives them. So today we're going to unpack the legal architecture of company shares, specifically for you, the business owner, to show you exactly how to structure your equity deliberately.
We've got a really clear roadmap for today. We'll cover 1. What are shares really? 2. Issuing versus allotting shares. 3. The business owner's toolkit. 4. The power of preference. And finally, number 5. Changing shareholder rights.
Let's jump into Section 1. What are shares really? Time to shatter the ownership myth.
We're going to start by busting a massive misconception. It's a super common trap for founders to think that selling shares means giving away co-ownership of their company's actual physical stuff, the desks, the inventory, the intellectual property. But as this quote brilliantly points out, that is completely false. Established way back in the famous Solomon case, your company is a separate legal entity. Shareholders do not own your physical assets. What they actually hold are personal rights. The law calls these choses in action. It basically means they have personal rights to things like dividends, a return on capital if you ever wind up the business, and certain voting privileges. Giving someone a share doesn't mean they can just waltz into your office and claim 20% of your laptops.
So if they don't own the desks, what exactly is the difference between taking on an investor and going to a lender? Well, issuing shares makes someone a member of your company with equity. Their return depends entirely on how well the business performs. On the flip side, issuing debentures just means someone gave you a loan. They're a creditor, not a member. They have a legal right to be paid back regardless of whether you make a profit or not. Knowing when to bring in a partner versus when to just borrow some money is step number 1 in protecting your cap table.
Moving on to Section 2, issuing versus allotting. Let's look at the legal mechanics.
Founders constantly use the words allotment and issuance like they mean the exact same thing, but legally, they are completely distinct milestones. As cases like Conte v. Cupeglo proved, allotting a share is really just making an offer. It's an invitation. Step 2 requires the investor to actually accept that offer and pay up. But the real magic, the actual legal finality, happens at Step 3. It's only when you physically enter their name into the company's register of members that the shares are officially issued and their title is complete. So pro tip here, keep your register updated. Otherwise, your legal reality isn't going to match your boardroom handshake.
All right, Section 3, the business owner's toolkit. Let's talk about utilizing different share classes. You really aren't stuck with just one generic flavor of equity. The law allows you to attach preferred, deferred, or completely special rights to different shares. You can structure ordinary shares for yourself so you keep all the voting control while creating entirely different classes of shares to attract outside capital. Got an investor who just wants a steady return and has zero interest in running the day-to-day? Or maybe your company needs a really fast cash injection, and you have to offer premium terms to rescue the business. That is exactly where having different share classes comes into play.
Let's dig into Section 4, the power of preference, how to attract capital while keeping control.
We need to focus on preference shares because these are arguably your most powerful tool for bringing in money without giving away the steering wheel. I absolutely love this quote from legal scholar Philip Ebo Bonzi Simpson. He says the preference shareholder is like the chief waiting for their guaranteed pound of meat. You, the ordinary shareholder, well, you're out there hunting. If you only catch a rat, the chief gets the whole thing. But if you catch a massive elephant, the chief still only gets their 1 pound and you keep the rest. Basically, they take less risk and get their fixed return first, leaving you to keep the massive upside.
You do have to pay close attention to the fine print here, though. You absolutely must define if unpaid dividends are cumulative or non-cumulative. If you issue cumulative preference shares, any dividend you fail to pay this year rolls over, meaning you literally cannot pay yourself a single dime in the future until all of those arrears are cleared. If they're non-cumulative, a skipped year is simply skipped. As a growing business owner, choosing between these two is a massive cash flow survival decision.
Now here is a brilliant strategic maneuver. Redeemable preference shares. Historically, courts absolutely hated it when companies bought back their own shares. We saw this in the old Trevor v. Whitworth case, where they ruled it depleted the capital that creditors were relying on. But modern law allows it, provided you have strict safeguards. You can issue shares to get capital now and essentially force the investor to sell them back to you later. You just have to use a special share deals account funded from retained earnings or a fresh share issue to do it legally. It is honestly the ultimate founder's safety net.
Now, while preference shares usually don't come with voting power, the law does step in with guardrails to protect those investors. They actually get a vote in 4 critical scenarios. Number 1, if you fail to pay their dividends, they vote. Number 2, if you try to change the rights attached to their specific class, they vote. Number 3, if you're trying to remove an auditor, which touches heavily on financial transparency, yep, they get a vote. And number 4, if the company is being wound up, they are legally entitled to participate in that decision. You can't just take their money and shut them out completely.
Which brings us to Section 5, changing shareholder rights and navigating the rules of variation.
So, what happens when your business evolves and you need to change the deal you originally made? The law recognizes that investors make decisions based on specific promised rights. Under older common law, a company could just multiply its ordinary shares to massively dilute someone's voting power, and courts didn't really care because the investor technically still had 1 vote per share. But modern laws are different. They strictly look at proportions. If you attempt to diminish an investor's overall proportion of total votes or their proportion of dividends, you have legally varied their rights. You have to get a special resolution or written consent from 3/4 of that specific class. Long story short, there is no sneaking a dilution past them.
As we wrap up this explainer, I want you to look closely at your company's constitution and ask yourself this one vital question. Have you structured your shares to build your business or to give it away? Your shares are not just percentages of ownership. They are tools of control, leverage, and growth. By understanding allotment, using preference shares strategically to bring in the chiefs while you hunt, and safely navigating class rights, you protect both your company's future and your own upside. Don't just give away pieces of your business. Engineer them.